So in doing your corporate cleanup, this is just a short list that comes from a due diligence checklist that I work with when I'm doing corporate cleanup for clients. And it starts with getting copies of the organizational documents, and you say, well, here's a copy, and it's not signed, it's not certified, it's not the full copy, it's not the original copy. I mean, how many times do I do that with founders, and they hand me, or they'll hand me their minute book, and the minute book's nothing's been done with it since the company was formed 14 years ago or 20 years ago. So there's a lot of cleanup that goes into getting a company ready, because the buyer's council is going to be looking for this stuff. They're looking for the articles of incorporation of the organization if it's an LLC. They want to make sure that you're registered in every jurisdiction that you're supposed to be registered in. We have a client right now that's going through a sale, and they said, oh, we're registered everywhere. Our CPA handled it, and that was a red flag. Why was it a red flag?
They assumed it.
What's that?
They assumed it.
Well, they assumed it, but more importantly, the CPA was filing all the tax returns where they're supposed to file. But they weren't registered in the jurisdiction where they were supposed to be registered, because they had an office there, or they had people on the ground working there. And that's subjects you to penalties and interest in almost every state in the United States. So you've got to register the business, believe it or not, to be able to do business in a particular state. So if you're incorporated in Delaware and you're working in Virginia, you have to register in Virginia. If you've got people in Maryland, you've got to register in Maryland. There are fees that have to be paid every year. There are forms that have to be filed every year. If you do not do that, that's got to be cleaned up. You've got to have bylaws. You've got to have an operating agreement. We had a company that we sold last year. It was an S corporation, but it was an LLC. LLCs can elect to be treated as S corporations. They had their lawyer, their prior lawyer, prepare the operating agreement for the LLC. It was an LLC partnership operating agreement, which almost automatically caused an inadvertent termination of S corporation status by the way it was structured, just by the way the operating agreement was structured. We cleaned it up, got it taken care of before the buyer came in. It was a big private equity group. But it was, just a simple oversight. You as the owner don't know any different, but we do, and it's got to be taken care of. Shareholders agreements, minute books, stock certificates have to be issued because they have to be transferred in the transaction. Oftentimes when it's like 5 days before closing, we're still preparing stock certificates. But we don't like that as corporate lawyers. It's not synthetic equity, it's synthetic equity. I had a couple of typos in here. I was really, it was on Father's Day I was doing this, so no wonder. Making sure you have signed copies of everything in the files and organized files. On the employment and labor side, this is an area where we see constant non-compliance and always has to be cleaned up prior to the sale of the business. I told you about the situation with one company. They had 250 employees, over half of them had invalid I-9s. Remember that? A couple of sessions ago? An I-9 has to be obtained on commencement of employment, and it has to be properly documented, and you have to get the right documentation at that time. If you don't, believe it or not, penalties are significant, and they can mount into the hundreds of thousands of dollars. So if you haven't done it, you think, well, I don't need I-9s. I've got all these people have top secret security clearances. What do I need an I-9 for? Well, that's exactly the fact pattern we had. They all had top secret security clearances, but they didn't have I-9s in the file, or they weren't properly filled out and properly executed. W-4s, employment manuals, employee agreements. Is there an inventions agreement if you're dealing with intellectual property? Is there non-disclosure for every employee? Do they have non-competes or non-solicitation agreements? Are they signed and in their personnel files? The employment and labor people in our transactions get really busy when things are messy. And that's where we generate a lot of fees, unfortunately. It's not necessary. Another area where we see a lot of downfalls is ERISA compliance. What is ERISA? The Employee Retirement Income Security Act of 1974. It governs all qualified plans. You have to have copies of your plans. They have to be up to date. They have to be approved by the IRS. There are standard safe harbor plans. You say, well, I just went to Fidelity, or I went to a broker to handle all that, and they're handling it all for me. Are they? Are they doing exactly what needs to be done? Oh, and by the way, also what's covered under ERISA are health and welfare benefit plans. Your health plan, your dental plan, are all ERISA plans. So when you go to do due diligence on your company or on a prospective seller, you're looking for copies of these plans. You're looking for 5500s, which is the form that gets filed with the IRS every year. You're looking for audits in some cases where there's more than 100 employees, you have to get an audit, and so on and so forth. So there are many requirements under ERISA, and you want to make sure that annual non-discrimination testing is occurring on these plans. You don't think about it. You may be the trustee on the plan with full fiduciary liability, but you don't realize it. I've had my own firm, and I was the trustee of my 401k plan, and I watched that stuff like a hawk, because the downside of not watching it like a hawk means that I could be personally liable. So you definitely want to be aware of that. If you have a union shop, you'll have collective bargaining issues, and there are always reps and warranties and issues that go into that. You have to know who your key employees are that are going to be transitioned over to the buyer, because they're going to want contracts with them. They're going to want to be identified. And then, of course, one of the biggest areas that we run into problems with is Section 409A, which is really a tax CPA attorney issue. The plan may be non-compliant, may need to be corrected. Oftentimes it's not very difficult to correct it, other times it is. And so there are things that have to be done prior to the closing in order for the buyer to be satisfied that you're in compliance with Section 409A. It's on deferred comp, it's on severance, it's on phantom stock, and stock option plans. It covers all of those areas, as well as partnership equity, LLC equity. If you're non-compliant, by the way, income has to be recognized, an excise tax of 20% has to be paid, and interest, a premium interest tax has to be paid back to the date on which you should have reported the income in the first place, and it can be very, very costly. I'm working on one right now with another client. Contracts, customers, and suppliers. Big issue here is, do you have copies of all your contracts with your customers? Are they signed? Are all the amendments there? Number one. Number two, if you sell your company, do you have to get the consent of your customer? It might be a subcontractor you're working on with somebody else. Do you have to get the consent of the customer? Often there's a section in the contract that talks about assignment. Well, if you're selling stock or equity interests, you usually don't have to worry about the issue of an assignment, because you're not selling the contract. You're selling stock in the company. But often these assignment provisions will have change in control language that says, well, by the way, if you sell your stock, that's considered an assignment. You need our consent to do the transaction. So you have to have somebody with an eyeball on your contracts to understand that this is required. It's in the lease of your real estate. I guarantee you, if you have any competent landlord with competent legal counsel, your lease will have a change in control provision that requires consent of the landlord before you can assign or sell the company. My landlord can stop me? Yeah. Usually is one of the last holdups in these transactions.